Hello there. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. So I want to talk to you today about what not to include in your estate planning documents. Now, one important purpose of estate planning is to facilitate the transfer of ownership of your money and your property to your family and your loved ones when you pass away. For this transfer to be as stress-free and as efficient as possible, it is crucial that estate planning documents be thorough and provide the necessary information. Nevertheless, there is some information that should never be included in your estate planning documents, and we're going to talk about that. The first thing is your Social Security number. Now, you may think that it would make sense to refer to yourself and your family members or loved ones by using their Social Security numbers to ensure that they're correctly identified when the time comes. It is important to provide information in your estate planning documents that is sufficient to properly identify your beneficiaries, but using full legal names, including middle name or initial, is typically adequate. Now, providing Social Security numbers would leave the individual vulnerable to the risk of identity theft because there are several estate planning documents that may become part of the public record. Now, a will may need to be filed with the probate court at your death, or a power of attorney or a certificate of trust may need to be recorded if real estate is transferred. Once these documents are part of the public record, complete strangers will have access to this private information by making a simple request of the probate court or recording office and paying a small fee. Considering that in 2022 alone, the Federal Trade Commission received 1.1 million reports of identity theft, Social Security numbers should never be included in anyone's estate plan. Now, keep in mind that you may need to provide your family's Social Security numbers when you designate them as beneficiaries of your retirement or other accounts, but those forms never become part of the public record, and therefore they are not vulnerable to identity thieves. Similarly, unauthorized people may use account numbers to steal money from your accounts if those numbers are listed in your estate plan and become part of the public record. It is important to keep your account numbers in a secure location rather than including them in your will. You also should be cautious about making them readily available to family members unless you have designated one or more of them to act as your agent under a power of attorney, a guardian, a trustee, or a similar role that imposes a duty on them to act in the best interest of both you and your future beneficiaries. Think carefully about who you choose to act in these roles, because they will have access to important financial information. Keep in mind that although a family member may often be the best choice, sometimes even family members prove to be untrustworthy. In October of 2022, Kyle and Deborah Matson were found guilty in New Hampshire of theft after they made unauthorized purchases, payments, and withdrawals from Kylie's father's bank account between December 15th and August 26th. Kylie's father, who was 86 when he died in 2018, suffered from dementia. The pair was sentenced to serve several years in state prison and forbidden from caring for any elderly, disabled, or impaired adult. Now, rather than including account numbers in your estate plan, you should protect yourself by taking steps to avoid the disclosure of account numbers and other financial information except to someone you trust and have legally designated to act on your behalf. You also want to make sure that you leave any disparaging remarks out of your estate plan. Now, some may think that their will is a means by which they can have the last word, so to speak, in a contentious relationship. However, a few courts have held an estate or the executor of an estate liable for testamentary libel, that is, publishing a false statement that is damaging to a person's reputation in a will. For example, in the 1914 case of Harris versus Nashville, the plaintiff's uncle included the following in his amendment to his will. the sum of $250 to John Woodfin, $1 to William Woodfin, and $1 to Cleo Woodfin, the illegitimate children of my brother James, is all that they are ever to have of my estate. At that time, illegitimacy was viewed very negatively. So Cleo filed suit against the executor of the estate for damages, alleging that she was the legitimate child of her parents and that the codicil had been maliciously added to the will to blacken her character. Although the executor claimed that no cause of action existed against the executor themselves, allowing Cleo to pursue her claim for damages, the court actually disagreed and allowed the case to proceed. So it is prudent to call upon the better angels of your nature and use your will as a means for blessing those you love instead of blasting those that you dislike. Now, as experienced estate planning attorneys, we always make sure that the information necessary to achieve your wishes is included in your estate planning documents, and that anything that would risk damage to your estate and ultimately your beneficiaries is excluded. So if you live in Massachusetts or New Hampshire, we're happy to help you with your estate planning needs. Otherwise, reach out to your local qualified estate planning attorney to make sure you have a proper plan in place for your loved ones. So I want to thank you for watching. Please like and subscribe our page if you want to learn more about estate planning and the benefits it has for your family. Till next time, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning to everyday families.